Hi, everyone. Thank you so much for being here. My name is Moira Donegan. I am the writer in residence here at the Michelle R. Clayman Institute for Gender Research at Stanford. And as part of that role, I have the honor of organizing this wonderful series called Feminism in Theory and Practice, where we bring some of the smartest minds writing about gender and policy in the American context here to talk with us at Stanford. And today we have one of my personal favorites, a hero, a genius, a really like wonderful and incisive legal commentator, Madiba Dennie of Balls and Strikes. I'm going to read her bio because I can't do her justice. So, Madiba Dennie is the author of The Originalism Trap and a deputy editor and senior contributor at the critical legal commentary website Balls and Strikes. She is also the co-director of the Democracy Committee of the New Jersey Reparations Council and was previously a counsel at the Brenner Center for Justice. Her legal and political commentary has been featured in The Atlantic, The Washington Post, and elsewhere. She has taught at Western Washington University and New York University School of Law, and Denny is a graduate of Columbia Law School and Princeton University. Madiba is a writer who I have looked to make sense of the rapidly transforming legal landscape that we've seen over the past really 20 years in the US and how that transformed judiciary has meant that we have to rethink policy and what those policies mean for gender justice in the US. And she is also just a really uncommonly intellectually generous person and an excellent communicator. So I don't think there's anybody I would rather have here to tell us about these transformed courts and what they mean and what we as feminists are staring at down in this uncertain future. So Madiba, thank you so much for being with us.
Thank you, Moira, for that glowing introduction. I feel like I have a lot to follow through on now. But yeah, thanks so much for having me. Always great to chat with you, and great to talk with students and folks in university communities. I'm also saying "with" deliberately because this is not going to be just me talking at you all the whole time. I welcome questions and conversation. So to start though, I want to talk a bit about what it is that I'm doing and why. I have somehow been out of law school for almost a decade now. So I've had the chance to work in a bunch of different spaces, including some nonprofit work, some government work. But for the past 2 years, I have been writing full time about the law. And writing about the law in a way I think is different from most of the legal commentary you may regularly encounter. I think about the law critically. I try not to take what the courts say at face value, and there are abundant reasons for this. Just to give an example, the Dobbs decision comes to mind. In that case, the Supreme Court overturned Roe v. Wade, rescinding the constitutional right to abortion. And in doing so, the court's conservative supermajority was like, well, we are not making a ruling for the country like Roe did. Roe was an inappropriate usurpation of power and like set this standard for abortion nationwide. We are sending things back to the states. Also, women are not without political power. So if women have a problem with this, they can vote about it. And that is something that there's just like a lot of plot holes there. Like they're saying we're sending it back to the states when in reality we know that these states are gerrymandered to hell. We know that folks like voter suppression is a thing. We have seen folks make ballot initiatives to codify abortion in their either in their state like statutes or in their state constitutions, and we've seen elected officials and some members of the judiciary go out of their way to try keep those democratic initiatives off the ballot. So actually preventing people from voting on it, as like right after the court was pretending that this was some big democratic thing they were doing. And they're saying sending it back to the states as if we don't know that the conservative legal movement has also been advocating to reinvigorate the Comstock Act, which is a really old-timey law that's been defunct for a while that makes it so you can't send obscene things through the mail. And under their argument, that would include things like abortion pills, birth control pills, even nationwide. So there are all sorts of things here that don't really cover the full picture if you were to just take what the court was saying at face value. You might say, oh, okay, sure, a woman can vote about it, not knowing that women were about to be prevented from voting. So these are the kinds of things I try to think about. Um, and I also really try to make clear in my writing what the law means to real people, especially people who are usually marginalized, like women and people of color of all genders and so forth. I think that often when we get sort of like mainstream legal coverage, uh, it's a little abstract. It's a little lofty. It doesn't say what the actual consequences on people are. Uh, and so there's a disconnect here because it's your regular people who are going to feel the brunt of the law's force. So I also try to strip down that legalese and make the law digestible, make it make sense for make this nonsense make sense for regular people. Uh, I basically, I guess, see my role as somewhat of a translator for what the courts are doing, and but trying to include what they are not saying, as well as what they are saying. Um, so I've gotten to do this in a few different ways over the past 2 years in my new life as a full-time writer. For the first half of that, I was working on my book, The Originalism Trap, which is out now, as you can see behind me. And since September of 2023, I have been at Balls and Strikes. Uh, Balls and Strikes is a legal commentary outlet that was launched in 2021. So it's a fairly new site, and it's sponsored by Demand Justice. Demand Justice is a nonprofit organization that works on court reform efforts, judicial nominations, and related issues. But even though they sponsor Balls and Strikes, they don't control what we say, and we don't speak for them. We have like a lot of room to really cover the legal issues we think are important and to like shape the way we think these issues ought to be covered. Uh, because Balls and Strikes really emerged from seeing problems both with what the courts were doing and also how the media covers the courts, sort of like leaving out swaths of people, as I mentioned. Also, entertaining the premise that law is neutral and that there can be such a thing as a neutral application of law without really factoring in, you know, who wrote these laws, who was advocating for them and why, who is the person interpreting them, what policy goals might they have? What will the real world consequences of this be? And so too often, uh, a little less so recently because it's getting harder and harder to keep up the charade. But people were trying to divorce politics and policy from law in a way that really didn't make sense, especially as I would argue, the judiciary has really been acting as like a legal wing of the Republican Party, uh, especially after the way it's been so transformed in the past few years, just like numbers game of stacking the courts entirely with folks who are friendly to conservative and corporate interests. Um, a lot of this coverage, a lot of mainstream coverage also does, you know, the sort of like both sides kind of thing, or like, you know, here, this person says A, this other person says B. Who is to say what is true or or what the impact of those things are? We were tired of the courts running amok, and also it just sort of not getting through to people what the courts were doing and why it's bad. Yeah, so our bio for Balls and Strikes on Blue Sky is that we're a site for progressive, bullshit-free commentary about the courts, judges, and the legal system they uphold. Um, Now, I think Mora, you'll have to tell me if folks can chime in with questions, because I do have a question for folks. I want to ask if anyone gets the name Balls and Strikes, if they understand what we're going for.
I
Sorry
know.
to put you on the spot, you know.
Well, this is I always interpreted balls and strikes. And for anybody who has a question for Madiba or for any of us, please feel free to type your questions into the Q&A box, which is just at the bottom of your screen here. And that way we'll be able to see them and we can like forward those on to Madiba and make sure that everybody gets their questions answered. But I understood balls and strikes to be a clever play on a comment on the role of the judiciary made by a little fella named John Roberts, who said that it was the judge's job, or he understood his job as a Supreme Court justice to be analogous of that of an umpire in a baseball game, right? He says, I'm just calling balls and strikes. And what I liked about the appropriation of that little catchphrase by your outlet, Madiba, is that it kind of it calls bullshit, right? It kind of makes the justice's own words a tool to use against him, right? Because I think what your coverage so often exposes is that the judiciary is often doing quite a bit more than simply calling balls and strikes, right? They're not really enforcing a neutral set of rules. They are often fixing the rules to favor one team.
Yeah, that's exactly right. We are we were like riffing on John Roberts's quote, sort of making fun of him a little bit, and the idea as he tells it that he's just an umpire. He's just calling it like he sees it, just calling balls and strikes. It's not his job to pitch or bat. And what's kind of funny as well is that my uh, a colleague of mine at Balls and Strikes, Jay Willis, who's the editor in chief, he was like, even in baseball that doesn't work because each umpire has their own different strike zones. Like people will call things differently depending on their perception of this, that, and the other. And just the other day, I was reading an interesting law review article that is coming out now. It's like the forward in the latest issue of the Harvard Law Review, and that sort of touched on this balls and strikes concept a bit more, saying how it goes even further than that. They're not just calling the plays, they're fielding the team, as they were talking about how like what role the justices play in selecting what cases to hear in the first place. They get to shape a lot of their docket. Like we hear some major cases on gun control, for example, because the court wanted to hear those cases. They have a lot of discretion over what appeals they take up. Most petitions get denied. So there's a reason to think, why were these petitions for a Supreme Court case granted? What was the court looking to do here? Were they looking to change the law? Were they trying to actually just like set straight and misapplication of law? Or they're trying to stave off another problem. So there are a bunch of different things going on in the way that legal decisions come to be that sort of really put to makes it clear that it's just not true that it's this neutral, thoroughly impartial, abstract exercise. Like these are real political decisions that have like real political effects on people's lives. So working at Balls and Strikes, I write regular articles, publishing a few times a week. Very, very different from just sort of working on a book project full time. Yes, not to mention problems in the selection and approval process of umpires. I'm seeing that comment here. Correct. A lot of issues there that we can get into later if you so desire. Um, So thinking about how I try to do my work at Balls and Strikes and like what it is that I do. Again, I have a lot of leeway, and so I try to pick my article topics sometimes based on what's happening at the Supreme Court. Like if I see a decision or a case coming up where I'm like, this is going to affect like trans kids, for example, for like the Scrimeti case coming up, about whether or not uh, a state can just ban a type of healthcare for a type of person, which Dobbs is not a good sign for. So seeing, like how is their Supreme Court decision being expanded on? Like what could the consequences of this be? What risks are there for the court's decisions? So especially, so yeah, so especially things about it seem like this kind of like landmarky decisions. Those are always, top of mind. I also though sometimes look at things that might be bubbling up at the like the circuit court level, which is just below the Supreme Court, or even for state Supreme Courts. State Supreme Courts are generally slept on in our sort of like mainstream legal media, even though they have a ton of power. The vast majority of legal cases in the United States are heard in state courts, not actually in federal courts, because that federal courts have so many of the flashy ones. But there's a lot of stuff going on in state courts, and so that can sort of be like a canary in the coal mine sometimes about like what kind of legal challenges are emerging, and also just what's affecting people's lives, and no one's it seems like a big deal but no one's actually talking about it. And I think the sort of like third well yeah third bucket would be talking sort of like meta pieces, talking about if I see like particularly bad media coverage or just like talking about some like legal culture more broadly issues. um and so let me see, I did Supreme Court, lower court slash state courts, media. I could have sworn I had one more. I'll come back to it. Uh, but point is, I got, oh, yes, okay, I remember now. The other sort of topic I'm on the lookout for is things that just really strike me as egregious, as things that are just examples that really like elucidate some of the harms of the legal system, or like longstanding issues that weren't being addressed. Or if I see something that is shocking, I feel like folks are talking about something like, I just read this crazy thing in the news, like what's going on there. I want to try explain that for people, so they can get a handle on what's going on there, and like what it actually means. An example of that would be the Disney Plus lawsuit folks might have heard about, and when a woman died on a Disney owned property because she had a deadly nut allergy and was served food with nuts in it, despite the restaurant saying it didn't have any. And her widow tried to sue, get some like monetary judgment for the Disney's negligence, and they tried to say you can't actually, because you signed up for a free trial for Disney Plus a few years ago, and that a free trial thing contained an arbitration clause. And so that means you gave up your right to be in court and have to go through a third party mediator that we select. That's outrageous. And so it was getting some attention as to like, how can this possibly be? So I tried to explain the sort of like legal landscape that made something like that possible. Like, here's the sort of friendliness to corporations and like to arbitration that the judiciary has been building up over time, that has empowered these sorts of corporations to feel so bold as to make this kind of egregious argument. Um, and explaining, like why something can be legal and still be wrong. It can still just be like morally wrong. Or something sometimes it can also just still be like questionable legality. Just sort of like bold strategy, and let's see how that plays out for him. So explaining that kinds of stuff for lay audiences is, I think, one of the things I try to do. Uh, yes, someone is raising that the same issue happened in the case of Uber as well. That's right. I also wrote about that case where someone was in a car accident while using one of the like rideshare services, and Uber said, "Well, your daughter ordered Uber Eats on your phone, so because you got pizza for dinner that one time, you can't sue over a car accident." These things that just boggle the mind, and yet again, like we're now we're seeing a little bit of a trend, like we're seeing this like it's happening again. Like Disney walked so Uber could run. So trying to get this sort of information out there so people know what the legal lay of the land is and can feel, I guess, appropriate level of anger at it as well. I want folks to realize that the court is capable of and too often does inflict harm on them, and explains it away using these like nonsense rationales, like trying to use the arbitration clause to prevent liability in a car accident. Or in the case of Dobbs, using originalism, saying, well, I don't see a historical evidence of people having a right to abortion, so you can't have rights now if you didn't have rights back then. That is anti-intellectual, in addition to just like furthering the subordination of like a whole class of people. And so I think it's important to tell non-lawyers as well, hey, this is legally and intellectually and morally bankrupt. There's like nothing okay about this. So you should not feel like you just have to sit back and accept whatever the court does. You don't have to feel like, oh, they must know better than me, like they have that job for a reason, like they got appointed to the court somehow. So I see my role as telling people, they can still be full of it. And like sometimes they are, and like sometimes they're just, partisan actors doing partisan things, or sometimes they're furthering like corporate interests deliberately. There are like real consequences here that I think people should know about so that they feel empowered to do something about it. So that they feel like, maybe the court isn't this uh, totally impartial, neutral arbiter of law that I have been told. Maybe we should be thinking about court reform. Like maybe we should be thinking about term limits or court expansion or jurisdiction stripping, so on and so forth. Um, yeah, that's sort of the some of the goals of my writing, and like how I kind of pick the article topics that I do. I also really try to write in a way that I guess makes sense to lawyers and non-lawyers alike. I try to really explain the concepts. But also I write to have fun. If you've ever read some of my stuff, you'll see there are like lots of jokes in there, lots of pop culture references. And part of that is just because I personally find it entertaining. Also because, sometimes it helps people to get uh, their legal news, like vegetables, uh, like if they also get the dessert of jokes as well at dinner. Or what is it Mary Poppins says, spoonful of sugar helps medicine go down. And also I just think that the court really benefits, the judiciary and the legal system as a whole really benefits from the idea that, they are so above it all. They are, these like high-minded experts who are entitled to your deference, entitled to your respect. And so I think that there is some value in treating the court with a bit of irreverence, and sort of making fun of them, like calling them out when they're doing nonsense, because then it's like, instead of the emperors have no clothes, it's like the justices have no robes. You can sort of just see through the nonsense, and the little charade begins to fall apart when you poke fun at these sorts of institutions. Uh, they are susceptible to they can be hurt by satire. They can be hurt by sharp critique, and the combination of the two. So I write to inform, and also so I can have a little fun while making a little fun of the course. Um, so I see another question here actually. Let's take a look. Yeah, okay, I will definitely get to that later. Um, so thinking about like how writing works, who I'm writing for. Um, I try to, let's see. It's another, you guys are very active. Let's see. Meet and convince people. Yeah. Yeah. Um, so I think that there was a question about how we convince people to meaningfully engage with court reform, and I think that's one of the things I try to do in my writing, is sort of like make the case as for why it's necessary. Like I think that, you know, probably as recently as 2 or 3 years ago, like before Dobbs came down and the court rescinded abortion rights, or before Bruin came down when they dramatically expanded gun rights. I think probably at that point, you know, a lot of people would have been more hesitant about the idea of court reform. Um, they might not have really seen the reason why it was necessary, like not sure like what the big deal is. But I think now some folks are like, oh, I understand now. I see what the problem is. Or, you know, like once you make it clear to people, like, hey, doesn't it seem weird to you that this group of like 9 people are like the only people in our system of government who have their jobs forever, like literally for the rest of their natural lives? Like, doesn't it seem odd that the whole direction of our government depended on whether like one 80 something year old like little old lady could beat cancer like a third time? Isn't that weird that like government depends on that? So I think make you like introduce these concepts to people, and it becomes clear to them like, huh, it's a little weird that to have life tenureship, like maybe that shouldn't be a thing. And like, oh, this is like a little strange that things work this way. Um, so trying to inform people about like what's going on, and like what the problems with it are. So I see my reader, sort of coming back to us. I was thinking about, you know, like how and why I'm writing. I see my readers, well, I guess at balls and strikes, like sometimes people who are coming to balls and strikes are like folks who, you know, are already law nerds, are already like more progressive and are interested in, you know, like the some more about what's going on. But I try to see my reader as, you know, like just like a regular person, like who like may or may not be a lawyer. So I want to try like give them at least the amount of information they need to make an informed decision. So, you know, trying, I don't need to like overload you with some of the like nitty gritty technical in the weed stuff, but give you enough so that you have context, and so you like understand the scope of what's going on. Um, and it's been a really fun gig, having done it full time now for just over a year. I had freelanced with them a bit before I joined full time, and I do feel like it is already getting to a broader audience. Like seen the articles like reach like regular people, as it, you know, sometimes it might like cross over into like the Google algorithm. So when people search a case name or something that they might have heard about on the news, then like a balls and strikes article we wrote about it comes up. And I also know some that some like political aides or the elected officials they might work for sometimes read it, which is exciting. Um, one of the most one of the most interesting things I learned about my readership, I was telling this story online the other day, is that when I was in my freelancing for Balls and Strikes days, before I worked full time, I before I worked there full time, sorry. I would do the occasional piece for them, and I would, be clear that I was only speaking for myself. I didn't mention my day job anywhere. Uh, and yet, uh, a judge, a judge apparently, a federal judge, Googled me after reading my article and being put off by it, and like found out what my workplace was, called my employer and complained, and then my employer was like, "Yeah, you can't write for Balls and Strikes anymore." But jokes on that judge because now I write for Balls and Strikes full time. Um, so it was good for me to find out though that it is being read and is starting to ruffle some of the right feathers in addition to reaching people who I want to like educate about these topics. Um, let's see. I want to take a look at a few of these questions since there are a bunch coming in. Some about some legislation, some about, yeah, constitutionalism, court reform. Thanks. Uh, cheers. Yeah. Um, I am especially grateful for this question of do I think the jurisprudence should be fought by coming up with another form of jurisprudence? I think that is one way in which it should be fought, and a way in which I've given a lot of attention to. So I spoke about some of my work at Balls and Strikes, where there I do like more regular, like quicker turnaround pieces, like sort of not daily, but a few days a week articles. But I also have taken, a step back to like a longer term project to really talk about some of the broader threats of the conservative legal movement, like how they've manifested and what are some ways we can push back against that. Um, so I am really concerned with the rise of originalism. Originalism is this idea that the Constitution has a single meaning that is fixed in time. Originalists say that the Constitution is frozen at the moment of enactment, and we have to interpret the document today the same way it would have been interpreted 200 years ago. Now, for any of you who may be tuned into this who would have had a rough time 200 years ago, it might be like immediately clear to you that there are some problems with this mode of analysis, and originalists have used this originalist justices to really just uh, throw out precedents or like yeah or just really reshape the path of the law. Um, so I think the two really big cases that sort of like gave me like the final push I needed to write this were the abortion case and the gun case. So in the gun case, the court struck down a gun law that had been on the books for over 100 years on the basis that it was insufficiently historical. They said that a gun law is presumptively unconstitutional unless you can point to a sufficiently similar law that was on the books at the time when at least some founders walked the earth. It's an absurd way to think about to do legal interpretation. Just an absurd way in practice. Just like why is that the way in which you would do law? Does that make sense as a way to get to the like best results? And absurd in terms of like the kind of real life consequences it has for people. And conservatives present originalism as if it is again, neutral, as if it is objective. But really, as I make clear in the book, originalism arose as a backlash to the civil rights movement. Legal and political elites who were opposed to social advancements were desperate to find formal justifications to say, hey, all that hard won progress over time is actually illegal. So we're going to turn back time because that's what the Constitution demands, very conveniently. So I try to explain that this is just a trap that we should not fall into. Like some folks have tried to maybe say like, well, maybe we can use originalism to our own ends. And I see where their heart is at, because there are some good parts of history that originalists just ignore. They rely on history, and any history that actually is like progressive or like advances social justice, suddenly that history no longer matters. But I think that's also still a mistake, because I think it is validating their idea that our legal interpretation should be chained to a particular point in time in the first place, which I disagree with. Um, and I also think that, even if we were to use the point in time that progressive originalists say. They point to the post Civil War era with the Reconstruction Amendments. The Reconstruction Amendments are incredible, and even so, they were not as good then as they are now. Our understanding of them has evolved. Like the 14th Amendment was not understood before to apply to women. And Justice Scalia, some years back, like before he died, had like made a comment to that effect, being like, "Oh, like no one actually thought that the 14th Amendment applied to women. Like that's never what it was supposed to mean." So it is clear how dangerous originalism is for uh, you know anybody who is interested in not reifying the past and not like cementing and like concretizing these hierarchical systems that are already in place. If you want to break away from patriarchy or capitalism or racism, if you want to break away from these things, originalism is not your friend. So I try to make that clear in the book, along with many of the other there are again, it's a whole book. There are more flaws that I that I point out. Um, but I do agree with folks who try to do originalism but make it liberal, that the Reconstruction amendments are wholly underappreciated. The Reconstruction amendments are those amendments that were adopted in the aftermath of the Civil War, and their whole point was to transform an unjust society into an equitable multiracial democracy. It was designed to include people who elites had forced out of the democratic process. So I think these amendments tell us that the Constitution includes everyone, and we need to interpret the Constitution in a way that makes inclusive democracy real. So I call this inclusive constitutionalism, saying that we should be focusing our legal interpretation on the goals of the Reconstruction Amendments to end oppression and bolster full democratic participation. And that should be our reference point for understanding any part of the Constitution. It's a like the Reconstruction Amendments are a lens through which we should look at all of it. Um, so I argue in the book for what I call this inclusive constitutionalism instead of originalism. And I think that this is important for a variety of reasons. Um, One of them is that, like we need a different way of doing things. Like we can't just this is not working. This is unsustainable. This is having terrible results for the communities we care about. We need a different method. Uh, so I think that this is a method that I think is helpful for progressive goals, and also I think is really more true to what the Constitution is supposed to do. Like if we think about how the Constitution is supposed to facilitate our democratic society, So it doesn't make sense to interpret the Constitution in a way that does not do that. So I wanted to try, provide this as a tool for all sorts of people. Like again, like both law people and lay people. For lawyers, I think it would be useful for them to start, really trying to like theorize this, expand on these arguments, like make inclusive constitutionalist arguments in court. Let judges use it in their opinions. And for regular people, I think that it can be useful in that it gives you another way to conceptualize your rights, and it lets regular people claim the Constitution. I think the Constitution has a lot of salience with a lot of the country, and people can it can help your advocacy to frame something as a constitutional right. Again, we can look at the Second Amendment for this. Uh, it was very recently that our legal system has thought that there is an individual right to a handgun. That's something that just didn't actually exist under law until the NRA just like really advocated and really mobilized a lot of people to say, we think we have a Second Amendment right to a handgun. So I think that there's no reason why other activists can't do the same thing for better goals, for things that address their community's needs, and that it opens up new types of persuasion as well. Like people who are committed to the idea of constitutional rights might listen up. I think it, just offers a way to just transform the types of rulings we've been seeing. So all of that is elaborated on much more in the book. Um, how does this work with Sherilyn Ifill's work of reframing the 14th Amendment? Yeah, Sherilyn Ifill is a genius. I adore her. I think that her work is really interesting. And more if you also want to add to Sherilyn Ifill love.
I will join you in the Cheryl and Eiffel fan club. I think so much of the sort of like left-wing constitutionalism has really focused around the 14th Amendment and focused around this idea of in the kind of liberal version of the originalism that you're talking about, like the notion of a second founding, which is based on a more meaningful and robust vision of citizenship and who it
Hmm.
includes and what it endows you with the right to, right? So like the second founding when they said democracy, but more closer to for real this time.
Right. They're taking it a
Almost.
little more seriously, just a
Yeah,
little.
and I love your notion, Madiba, of like sort of expanding beyond liberal originalism, right? Because
Mhm.
you're right that there is this tendency among sort of left-wing lawyers, left-wing court watchers, left-wing jurists, or even just people who are, not reactionaries, to try and take the intellectual habits, the sort of like legitimacy granting forms that have
Mhm.
emerged out of the right-wing shift of the judiciary, and to try and appropriate them for more like small d democratic ends, right? More ends
Right.
of civil rights and inclusion. This is Ketanji Brown Jackson's like kind of signature move in oral argument.
Mhm.
I love Ketanji Brown Jackson. Don't take her away. I hope she lives forever. I hope she is having a great day right now. So she will go up there and be like, well, what about, she'll do competing histories, right?
Right, right, yeah.
The other kind of part of originalism is that it incentivizes some like just bad historiography, like some just like bad,
Mhm,
like
mhm.
fake history. But she'll do a competing history. She'll be like, well, what about these people who didn't have their citizenship recognized until the 14th Amendment, right? What
Yeah.
about that expanded set of rights? And what about people in those historical social circumstances? And how do we apply the law, presuming that they have the equal protection of the law that the Constitution nominally grants them, right?
Mhm.
And I think you're right that there's a way in which that's very pragmatic, right? And there's also a way in which it is ceding conceptual territory.
Right.
We actually don't need to cede, right? We can
Yeah.
think of a different kind of constitutionalism. And so
Mhm.
like I love Sherilyn Ifill. I think the idea of like expanding the 14th Amendment, trying to make it actually mean and have the effects that it says, trying to take the expansiveness and ambition of that particular amendment seriously, right? If we took
Mhm.
the 14th Amendment seriously, this would be a very different country.
Right.
Um, and so, like, there's a degree in which we already have the tools, right? And we know that we can
Exactly.
change and
Yeah.
expand what the Constitution means, and we know we can do that partly because the right has done it so much, right?
Yes. Mhm.
But then I also love your expanded vision of like moving beyond originalism. Do you want to like tell us a little bit more about your vision of constitutionalism before we dig
Yeah.
more into these amazing questions? We have a fire audience who are bringing their A game today.
Yeah.
Like
It is.
make your pitch for how we fix the Constitution, and then we'll dig more into these wonderful comments.
Sure. Yeah, I thoroughly appreciate all the comments and questions. It's like hard to keep up with them all as they keep coming in. Um, so I think you raised a good point, Maura, when you said that folks are trying sometimes to do what they think is the pragmatic thing about uh, forcing liberalism into this sort of idea that has been legitimized about, about originalism. And my question is, like, why try force liberal ideas into that legitimate thing instead of delegitimizing originalism? Because originalism is fundamentally flawed. Like you said, it incentivizes this bad history. I have two historians in my life. Like, don't even get me started. Who, they're like looking at what the court is doing, and it's just like that's not how that works. With this like bad history they use, and also again, like God bless Katashi Brown Jackson. Like she's doing her thing up there, by and large, when they're presenting some bad version of history that leaves out some like crucial fights for civil rights, and she like raises these things. But at the same time, I think we need to remember that she didn't win them over, because they don't actually care. They care about originalism, they care about history insofar as it produces the conservative results they wanted, insofar as it mobilizes the reactionary right. And so I think that by trying to do originalism but make it liberal, you are ceding this ground and not really getting anything in return. Because you're not going to make new friends, and you might even alienate some of your allies who are like, guys, like, why are we doing this? Like, don't give me that. We have to rely on history alone stuff. History alone wasn't good for the most part.
I
So
think
that's.
this might be a good moment to move on to one question, right?
Mhm.
From an anonymous attendee who asks, you probably answered this in your book, but do you think that most originalists actually believe what they're saying? I.e., are they actually arguing in good faith? Madiba, this is a
Mm.
question I ask myself every June when we get that new crop of opinions, right? Like, are they for real, or is this cynical? Is it opportunistic? And how do you tell?
I think mostly cynical. It's not always cynical, or not like fully cynical all the time. Sometimes there might even be some level of self-delusion in there. Like they might fully think that they think this they might believe what they're saying. But I think it often is clearly cynical. I think a really good example of that, and it showcases a bit of true belief versus cynicism, is in the Rahimi ruling. Rahimi was the first big Supreme Court gun case after Bruin, where the court invented that new gun standard. And in the wake of Bruin, a whole heap of gun laws were challenged, including this one that says it is unlawful for someone to possess a gun if they are subject to a domestic violence restraining order. So like if you have like an order of protection against you for being abusive to like a partner or a child, then you aren't allowed to have a gun. And folks challenged that law. There was someone who was arrested for violating the law, and he said, well, the court just said in Bruin that there needs to be a historical foundation for these laws. And there's no historical analogy for domestic violence laws because they just didn't exist back then. And the Fifth Circuit Court of Appeals accepted that argument. They said, you are right. The government didn't try to stop violence against women back then, so it is actually unconstitutional for the government to try to stop violence against women now. It was horrifying. And I think that when most of the court was confronted with that, they were like, "Oh no, hang on. That's we gotta back that up. That can't. This is a really bad outcome. We cannot have it said that we like rearm domestic violence offenders. I do not want this guy Zaki Rahimi to have a gun. If you have any spare time, you should look up some of the facts of Zaki Rahimi's cases. He is almost comically an irresponsible gun owner, just like really Yosemite Sam kind of dude who has never met a problem a gun can't fix. It's just like absurd. And so I think that much of the court felt the need to back up. And so that wasn't, honest application of originalism. That was pure pragmatism and political thinking. And you can see that in how in the majority opinion, the court is well, there are a couple things. One in the majority opinion, authored by, I believe it was John Roberts, he's like bending over backwards, coming up with random things to analogize. He's like, well, in 1400 in England, there was a law saying that you can't menace the good people of the land. And so maybe that is kind of like the restraining order. And it's like not, it's like very, uh, very tangential.
More recent precedents that and more local precedents that were thrown out by Bruin,
Right.
Like you
Like
don't
if you
actually have
find
to go
yourself,
back to there's
yeah.
impulse to legitimize from the past, right? The past
Mhm.
is in fact what grants legitimacy to the law. And speaking of the past, we have one really interesting question, which is from an anonymous attendee who asks, you said the Supreme Court is a legal arm of the Republican Party, I think. Is this totally new? Or is there a historical precedent for this? And that's something I've wondered about too. Like this politicization of our judiciary. Is that
Mhm.
new, or is that something that has already happened in the past?
I think it is new-ish. I think that the courts have always been political, but political has not necessarily so neatly overlapped with partisanship in the way that it does today, where we like have some who are like, okay, the Republican appointees are ruling for Republican interests, like, and they're going to do that like majority, if not all of the times. Also, it is new to have a sort of partisan litmus test in picking judicial nominees. That is a recent development that sort of coincides a bit with the rise of the Federalist Society. Some conservatives were disappointed with who was it? Was it Souter? There was a Supreme Court justice, and they felt let down. They felt like they didn't get their money's worth, and they said, "All right, no more suitors going on. Like from here on out, we are really screening people to make sure they're loyal partisans." And so now, you may have had like Republicans on the court before, but even like a George H.W. Bush Republican is different from a Trump Republican. And so even though the court had been political, it hadn't been this sort of like intense partisanship. Also, with the court taking on cases to advance the interests of that political party, whether their policy goals or even their like electoral prospects. Like we saw in some of the like gerrymandering cases and some of the Voting Rights Act cases, and in the 14th Amendment case about whether or not Trump could be on the ballot. The liberal justices are at fault here as well in deciding to disregard the plain text of the 14th Amendment because they were afraid of what would happen. But the Republican appointees were all too happy to keep their candidate, the standard bearer of their party, on the ballot, even though he is clearly constitutionally ineligible. Because we have a whole clause in the Constitution about if you were an elected official and you do an insurrection, you don't get to be an elected official again. And they just decided to do away with that. And so again, that again also shows some of the like cynicism cynicism about like originalism when it's convenient, originalism when it furthers our ends. And otherwise, when it doesn't, we'll just do our own thing. And so I think that it is important for people to sort of reject originalism as the one true method of legal interpretation, as the courts keep insisting that it is, despite all the evidence to the contrary.
I think this might be a nice point to turn to our next question from Bayan Shahin, and I'm so sorry to this person if I am butchering their name. But they ask, why do you think so many people are quick to believe the court is always right or neutral, right? Like, why
Mhm.
do these pretexts like originalism or like judicial neutrality continue to have such a grip on the American political imagination, right? Why is everybody still buying it?
Yeah. I think there are a variety of factors there. One is the media, which is like why Balls and Strikes is trying to, push back against these like dominant frames. I think that a lot of mainstream court reporters carried water for the courts for a long time, and sort of like acting like what they did was so, always objective, always high-minded and neutral. They also like I think you have said this in an earlier conversation, I think, about how opaque the court often is as an institution. And so there, and I think that media sort of is complicit in some of that and like cultivating this air of mystique of like, oh, what is it that the justices are doing? Like, who knows? They're going back in the deliberations, and maybe I will eventually be let into their confidence, and then in a couple years I'll publish a tell-all book about it, now that it's like too late to use any of this information. So I think part of it is failure of the media. I think part of it is also the court is benefiting from the sort of like historical memory of the court when it was doing better things. I think that a lot of liberal attorneys in particular are really nostalgic for the days of the Warren Court, that gave us like Brown v. Board of Education. And it is hard for them to accept and recognize that those days are long gone, that this is not the Warren Court anymore. But it's like they're not quite ready to part with that. And also, I guess like along those lines, people who, some who have been to law school or are law professors or have like dedicated their whole careers to thinking and writing about the law, might feel some kind of way to be like, oh, actually, is this all fake? Are they all just kind of doing their own thing? Is this just political ends? No, it can't be. I need to come up with this like reasoned thing otherwise. So there are a bunch of factors. I think another one is people might just think they don't know as much, saying like, oh well, like what do I know compared to a Supreme Court justice? Like they must know something I don't. Like uh you know, I took my civics class in middle school, and they said, the Supreme Court tells us what the law means, and yeah, okay. And
It
so
can't
people,
possibly be that the people in charge are cynical opportunists. It must just
right.
be that they look like that, but it must just be that I'm ignorant and don't
Right.
understand. That, yes,
Yeah.
it's a very common posture. I always want to be
Right.
like, no, 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 no. Like if it looks like a duck and it quacks like a duck,
It
like you
is
don't have
indeed
to
a duck.
like, yeah, you don't have to pretend that like it's like somehow this mystery about what it is.
Yeah.
Yeah.
And I also would add to that that again, the judges and justices like it that way. They get angry when you try to, when you try to change that. We got a I don't know if it was viral or just lawyer viral example of that the other day. The Federalist Society had their annual convention. Again, you know what I'm talking about.
Poor
Uh,
Steve Vladek, like that sweetest, gentlest man. And he just walked into a trap, I think.
Literally walked into a trap because, for unfamiliar listeners, Judge Edith Jones, who sits on the Fifth Circuit Court of Appeals, was a co-panelist with Georgetown law professor Steve Vladek at this FedSoc event. And this woman pulled out a folder with printed out copies of articles and amicus briefs and tweets that Steve had written that were like critical of the judiciary. and like blamed him for death threats that Judge Kazmayar got, and said, and she had this one line that was like,
Steve Braddock has been a critic of judge shopping, right? Like
yeah,
right-wing plaintiffs bringing cases, particularly to the Northern District of Texas, where there is one extremely right-wing judge.
right. And so he was trying to like raise the, trying to discuss how this compromises judicial independence. And instead, Judge Jones just spent her time attacking him and said that an attack on the judiciary is an attack on the rule of law. So she equated criticism of judges, and I'll have a piece coming up about this shortly in Balls and Strikes. She like equated criticizing judges with like anarchy. Saying you are a threat to the rule of law if you call out judges for their nonsense, which could have a serious chilling effect on people. If they're out here saying you're responsible for death threats if you point out that a bad judicial decision is bad, like that's so wacky and so inappropriate. So there are all of these things like this, all this sort of confluence comes together to make people think like they just have to accept what the court does. But I am begging you, listeners, to know you do not have to accept what the court does. And I explain so at length in the book.
I think that's a great place to wrap up. You do not have to believe what the judiciary tells you about itself. You can think for yourself. You can be a critical, irreverent, fun, generous voice like Madiba. And I am so grateful that we all got to have a little bit of your time and learn from you today. I feel more fortified to go ahead. So thank you to all of our wonderful guests. We had a really great turnout. We had a really engaged audience today. I think because Madiba is so like wonderful and exciting to hear from. And I hope you guys will come out to the next Feminism in Theory and Practice and follow us along. So thank you all. Have a great rest of your day.
Thanks, Moira. And thanks, audience.